Section 3.70. A. Claims for abandoned property. A. Any person claiming an interest in property surrendered to the treasurer under the provisions of this part may claim such property, or the proceeds from the sale thereof, at any time thereafter. Any person claiming an interest in such property shall file a certified claim with the treasurer, setting forth the facts upon which such party claims to be entitled to recover such property. The treasurer shall prescribe the form that such a verified claim shall take. B. The treasurer shall consider each claim not later than 90 days after it is filed. The treasurer may hold hearings on any claim and may refer any claim to the office of the Claims Commissioner, which shall hold hearings thereon and promptly return the Claims Commissioner's recommendations for the payment or rejection thereof. The treasurer shall deliver the treasurer's decision in writing on each claim heard, with a finding of fact and a statement of the reasons for the treasurer's decision. Any person aggrieved by a decision of the treasurer may appeal therefrom in accordance with the provisions of Section 4 to 183, except venue for such appeal shall be in the Judicial District of New Britain. C. 1. A. No agreement entered into prior to January 1, 2023, to locate property shall be valid if I. Such agreement is entered into I. within 2 years after the date a report of unclaimed property is required to be filed under Section 3 to 65A, or I. between the date such a report is required to be filed under said section and the date it is filed under said section, whichever period is longer. I. Such agreement is entered into within 2 years after the date of posting of the notice required by Section 3 to 66A, or I. Pursuant to such agreement, any person undertakes to locate property included in a report of unclaimed property that is required to be filed under Section 3 to 65A for a fee or other compensation exceeding 10% of the value of the recoverable property. B. No agreement entered into on or after January 1, 2023, to locate property shall be valid if I. Such agreement is entered into I. within 2 years after the date a report of unclaimed property is required to be filed under Section 3 to 65A, or I. between the date such a report is required to be filed under said section and the date it is filed under said section, whichever period is longer, or I. Pursuant to such agreement, any person undertakes to locate property included in a report of unclaimed property that is required to be filed under Section 3 to 65A for a fee or other compensation exceeding 10% of the value of the recoverable property. 2. A. In addition to the requirements set forth in subparagraph B of subdivision 1 of this subsection, an agreement entered into prior to January 1, 2025, to locate property shall be valid only if it is in writing, is signed by the owner and discloses the nature and value of the property, and the owner's share after the fee or compensation has been subtracted is clearly stipulated. B. In addition to the requirements set forth in subparagraph B of subdivision 1 of this subsection, an agreement entered into on or after January 1, 2025, to locate property shall be valid only if such agreement is in writing, is signed by the owner and clearly and conspicuously discloses I. the nature and value of the property, I. the owner's share after the fee or compensation has been subtracted from such value, and I. that the owner may file a claim directly with the treasurer at no cost and the method through which such claim may be filed. 3. Any solicitation made to locate unclaimed property shall clearly and conspicuously disclose in a written statement that a. Any individual may search for and file a claim for such property directly with the treasurer at no cost, and b. the method through which such claim may be filed. 4. Any claim for unclaimed property filed with the treasurer pursuant to an agreement or solicitation under this subsection shall include an unredacted version of any such agreement or solicitation to permit the treasurer to determine whether such agreement or solicitation complies with the requirements of this subsection. 5. The treasurer may withhold payment of a claim for unclaimed property to anyone other than the owner, a. for failure to comply with the requirements of subdivision 4 of this subsection, or b. if the treasurer determines that the solicitation or agreement to locate unclaimed property does not comply with any other requirement of this section. 6. Nothing in this section shall be construed to prevent an owner from asserting, at any time, that an agreement to locate or to otherwise obtain an interest in unclaimed property is based upon excessive or unjust consideration. D. The treasurer shall pay each claim allowed without deduction for costs of notices or sale or for service charges. The treasurer shall notify the Commissioner of Revenue Services of the payment of claims of $500 or more to the domiciliary administrator or executor of a deceased owner. E. In the case of any claim allowed under this section for property, funds or money delivered to the treasurer pursuant to subdivision 1 or 2, a subsection A of section 3 to 57A, the treasurer shall pay such claim with interest as follows: for each calendar year or portion thereof that the property, funds or money has been paid or delivered to the treasurer shall pay interest at a rate that is not less than the deposit index, as determined under section 36A26, for such year. Such interest shall accrue from the date of payment or delivery of the property, funds or money to the treasurer until the date of payment or delivery of the property, funds or money to the claimant. F. Notwithstanding the provisions of subsection A of this section, where the amount of a property reported or transferred to the treasurer under this part is less than $2,500, the treasurer shall pay such amount to an individual if the treasurer has determined 1. That such individual is the sole owner of such property, and 2. To the treasurer's satisfaction, the current address of such individual. G. The treasurer may make direct payment to one or more claimants, without such claimant having been granted a decree to transfer personal property, been issued a current fiduciary certificate, or secured any other similar document, for any solely owned unclaimed property of a deceased owner valued at less than $500 in the aggregate at the time of the claim, subject to the following conditions. 1. If no affidavit in lieu of administration or similar petition has been filed in a probate court or more than 1 year has passed since the last decree to transfer personal property or any other similar document has been issued, upon a claimant furnishing a certified claim and a sworn affidavit under penalty of perjury showing entitlement to such property. Such affidavit shall be in a form prescribed by the treasurer and shall include, at a minimum, a. The claimant's affirmation that the claimant is the sole heir, or b. Attestation from all of the other heirs with a valid claim to the property confirming the rightful distribution of the property under the law. 2. If a fiduciary of a decedent estate has been appointed by a probate court, but the decedent's estate was closed more than 1 year prior to the discovery of the relevant unclaimed property, upon a claimant's furnishing of a certified claim and a sworn affidavit under penalty of perjury showing entitlement to such property. Such affidavit shall be in a form prescribed by the treasurer and shall include, at a minimum, a. The claimant's affirmation that the claimant is the previously appointed fiduciary and that the claimant shall distribute the funds as required by law, or b. Attestations from any rightful heir or beneficiary consistent with the provisions of subdivision 1 of this subsection. 3. The payment of the amount due under this section shall constitute a full acquittance and release of the state for the amount paid. Any claimant paid by the treasurer in good faith shall be answerable concerning such payment to anyone prejudiced by an improper distribution or payment. Except as provided in this subsection, nothing in this section shall be construed to modify or eliminate any of a claimant's responsibilities under any other state or federal law, including, but not limited to, any obligations under Title 45A.